So this is an interesting area because the hurdle is now so high. Previously, an employer who was facing a very difficult and always sensitive case of sexual harassment in the workplace would be able to point to a series of measures that they'd taken to prevent sexual harassment.
But notably, the law is rather retrospective as it currently stands. So if harassment occurs, the law currently deals with the aftermath of what happens. So the strengthened position of the ERB means that employers will be required to take all reasonable steps to prevent the harassment from taking place in the first place.
What that means is that if the employee's barrister or solicitor can say, well, actually, I've got 2 or 3 examples of other steps that you could have reasonably taken here, even if it's just one thing that they could have done that they didn't, that will be enough for the employment tribunal to make a finding that there has been a failure to prevent sexual harassment. So it's really important that the employer exhausts all those possibilities. What we would advise is that you look at your working environment as a whole. What is the culture of your organisation? What are the possible risk areas? So, for example, where we see workplace banter, where there is horseplay. I mean, these are the kind of terms that give employment lawyers nightmares. Anything where there is sort of a pressure or an imposed expectation that you'll indulge in, drinking culture, pressure on younger staff to stay out late, discouragement, intimidation, or a lack of a speak-up culture can be something that needs to be addressed.
Examples of reasonable steps that can be taken include having an express anti-harassment and bullying policy that's regularly communicated to employees. It's actually reviewed periodically and not just brought out for new starters. With training, it's not simply enough just to have a one-off. It should be regular and it should be appropriate for the level of that employee as well. We've talked about appropriate channels. These channels for employees to raise concerns should be without fear of retaliation. A lot of these things, organisations, at least the organisations I work with, have them in place. It's just going that step further, especially with the inclusion of employers being liable for third-party behaviours.
And this is an interesting development. The hurdle, again, is really high. It has to be all reasonable steps to prevent third-party harassment. There are certain sectors where this is going to be really prevalent. So hospitality, for example, if you've got lone workers, might be carers, for example, in the homes of clients. Even teaching, for example, if you've got pupils acting inappropriately. Much will hinge on what an employment tribunal will deem reasonable. Obviously, if the employee is offsite, it's difficult for the employer to control that environment. But if the employee is acting in the course of their employment, then the employer is going to be vicariously liable for any of that harassment that might take place.
So the inclusion of third parties within employer liability means that there is a potential increase for the risk of claims being made. So this is, of course, a huge legal risk, but also a reputational risk for employers.
One of the inadvertent consequences of this new law could be that employers take the extreme view of using contractors, using agency workers, and just scrapping the idea of using employees where there is a significant risk of a third-party harassment claim. Alternatively, they might adapt their recruitment processes. So if they're recruiting, let's say, for bar staff, they might say, well, actually, no, we don't want a young girl behind the bar. We want somebody who's either a lot older or we're just going to stick to male staff. It's interesting to see how it'll develop. I think there will be some inadvertent impacts that will come out in the wash, but it's still yet to be seen.
It's still an unknown of how this is going to work in practice, but if you think about the administrative burden of those reasonable steps can be excessive if you're looking at policies, training, appropriate channels, but also you may have tensions rising between protecting your employees without escalating disputes with customers, for example. From an office perspective, we may find ourselves in a position where employers are taking an overly defensive position when it comes to the interactions between staff members. You could find that team culture could dissipate or be deemed to be negative in light of new changes. We could see an overregulation of how our employees are dealing with third parties, which could lead to a lack of autonomy for a lot of employees, which can be something that's so important to them. There could be unintended changes across the board. It's such a wide area